Welcome to Clue, Criminal Law for UK Enforcement. It's only a small amount of drugs. Here's what UK law says about possession. In UK law, possession of a controlled drug is a criminal offence under Section 5 of the Misuse of Drugs Act 1971. The law applies to drugs classified as Class A, B, or C. A person can be prosecuted, even for a small amount, intended solely for personal use. Possession alone can lead to arrest, charge, and a criminal record. To fully understand the offence, let's answer what is possession. Possession means that a person has knowledge and control of a substance. It may be actual, physically held, or constructive, such as drugs stored in a drawer or car. The law focuses on control, not ownership. If you knowingly keep drugs within your access, even if they belong to someone else, you are in possession legally. For someone to be charged with possession, the prosecution must establish the following points to prove. 1. The substance is a controlled drug under UK law. 2. The defendant had custody or control of it. 3. The defendant knew or should have known of its presence and character. Each element must be satisfied beyond all reasonable doubt for a conviction to follow. Let's now look at drug classes. There are 3 different classes of controlled drugs. The first and most serious of the 3 are Class A drugs. These are considered the most harmful. Examples include heroin, cocaine, including crack, ecstasy, MDMA, methadone. Possession can result in a sentence of up to 7 years and/or an unlimited fine. Offences involving supply or production carry significantly higher penalties. What are Class B drugs? Class B includes drugs that are harmful but less so than Class A's. These include cannabis, amphetamines, speed, barbiturates, codeine when misused. Possession may lead to up to 5 years in prison. The law treats repeat offences or aggravating circumstances more seriously at sentencing. What are Class C drugs? Class C drugs are considered less dangerous but remain illegal to possess without a prescription. These includes diazepam, Valium, anabolic steroids, GHB, gamma-hydroxybutyrate, CUT. Possession of Class C substances may result in a sentence of up to 2 years and/or a fine. In addition to possession, the Misuse of Drugs Act 1971 covers several other offences. Possession with intent to supply, supplying or offering to supply, production or cultivation, importation, exportation. Each offence carries its own sentencing range, often far greater than simple possession. Let's go over each so we know what they are and when the offence is completed. Possession with intent to supply. A person is guilty of possession with intent to supply if they are found with drugs and evidence indicates an intent to distribute. Indicators include large quantities, scales, deal bags, cash, communication, texts, calls. Intent may be inferred even if no supply occurred. The maximum penalties depend on drug class and amount. Supplying or offering to supply. Under Section 4 of the Misuse of Drugs Act, it's an offence to supply or offer to supply controlled drugs. You don't need to complete a sale. Just making an offer is enough. Even giving drugs to a friend for free can count as supplying. Evidence like texts, cash, or photos can support a charge. Even if no drugs are found, you can be charged with being concerned. Production or cultivation. Production includes making, preparing, or growing controlled drugs. Cultivating cannabis plants, for example, counts as production. This applies whether it's for personal use or distribution. Equipment, lighting systems, and large-scale setups are common indicators. Penalties vary by class and scale of operation. Importation and exportation. Importing or exporting controlled drugs, bringing them into or out of the UK. is an offence under Section 3 of the Misuse of Drugs Act. This includes postal shipments and travel smuggling. Border Force and customs officers are trained to detect this. Sentences are severe, especially for Class A importation offences. Case law, R. v. McGuinness, 1987. The House of Lords ruled that retaining drugs for future delivery can constitute supplying. Even holding drugs temporarily with the intention of giving them to someone else may qualify. The law does not require sale or profit, only intent to transfer possession to another person. What can be a defense? Honest mistake. Strong defense may arise if a person genuinely did not know they had drugs in their possession. For example, if a friend left a jacket in your car with drugs in the pocket and you were unaware, you may not meet the legal threshold for control or knowledge. However, this defense must be credible and supported by evidence. Let's recap. Possession is when you knowingly have control over a controlled drug, even if it's not yours. Supplying includes giving, offering, or planning to pass drugs to someone else. Drugs are divided into Class A, B, and C based on harm. Offences under the Misuse of Drugs Act include possession, intent to supply, actual supply, production, and import or export. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time.